Well, let's make a start. First of all, welcome everyone to today's roundtable discussion. My name is Andrew Godwin. I'm a Professor of Commercial Law and one of the Associate Directors of the Melbourne Centre for Commercial Law, which is one of the host bodies or centres along with the Melbourne Centre for Environment and the Law. I'd like to begin by acknowledging the traditional owners of the land on which we meet. In our case, here at Melbourne Law School, it's the Wurundjeri, Woi Wurrung and Bunurong peoples. I'd like to pay respects to their elders, past and present, and also extend a warm welcome to any Aboriginal and Torres Strait Islander peoples who are joining us today. Thanks to all of you for coming along. It's great to see you here, to hear what I think will be a very interesting discussion by our special guests. It's likely, I think, that all of us have had something to do with, seen reference to, drawn on the work of UNIDROIT in one form or another. UNIDROIT is the International Institute for the Unification of Private Law, an independent intergovernmental organisation with its seat in Rome. UNIDROIT is celebrating its 100th anniversary this year. I think the Secretary-General will say more about that shortly. As noted on UNIDROIT's website, its purpose is, and I quote, to study needs and methods for modernising, harmonising and coordinating private and in particular commercial law as between states and groups of states, and to formulate uniform law instruments, principles and rules to achieve those objectives. I've frequently drawn on the work of UNIDROIT in my own research, just to name a couple of instruments, the UNIDROIT Principles of International Commercial Contracts, which was first released, I think, back in 1994, and more recently, the Principles of Digital Assets in Private Law, which was released in 2023. The instruments that UNIDROIT has produced over the years cover a very broad range of areas, including insolvency law, international sales, and security interests. So we're extremely honoured and privileged today to have 5 special guests who have worked in or for UNIDROIT in different capacities. Let me introduce each of the speakers. Our first speaker is Professor Ignacio Tirado, who is the Secretary-General of UNIDROIT, a position that you've held since 2018, I understand. Professor Tirado has extensive experience in other organisations, including the World Bank and the Asian Development Bank. He is also a founding member of the European Banking Institute, an international fellow of the American College of Bankruptcy, and has been director and academic co-chair of the International Insolvency Institute. Our second speaker is the Deputy Secretary-General, Professor Anna Veneziano, who is a Professor of Comparative Law at the University of Teramo, Italy. Professor Veneziano's main research and publication areas are on secure transactions as well as international comparative and European contract and sales law. Our third speaker is Mr. Bruce Whitaker, I understand, or is it Professor Hara? Oh, Professor Hara, my apologies. Our third speaker is Professor Megumi Hara. Professor Hara is a Professor of Law at Chuo University School of Law in Tokyo, where she teaches and researches in the area of property, contract, secure transactions and trust law. Professor Hara has served as a member of various UNIDROIT working groups and has published numerous articles on secure transaction law, property law and other topics concerning civil law. Fourth, Mr. Bruce Whitaker, who is an honorary senior fellow at Melbourne Law School and a former partner in the finance practice at the international law firm Ashurst. Bruce has been actively involved for many years in secure transactions law reform in particular, both within Australia and overseas, and has worked closely with UNIDROIT on a range of projects. Last but certainly not least is Mr. William Bridie Watson, who is a senior legal officer at UNIDROIT. Will specialises in international instruments related to access to credit and secure transactions law. Within the Institute, William also manages the UNIDROIT Scholarship, Internship and Research Program. And I note that many students from Melbourne Law School have participated in that program at UNIDROIT. William is a law graduate at ANU and previously worked for the Commonwealth Attorney General's Department in Australia. So in terms of the format for today's seminar, the Secretary-General will first provide an introduction to the history, mandate and main work of UNIDROIT. He will then be joined by the Deputy Secretary-General to talk about various instruments that support sustainable economic development. Bruce Whitaker and Professor Hara will then outline Australian or Japanese and Australian approaches and experiences in negotiating instruments at UNIDROIT. And following them, last but certainly not least, will discuss opportunities to work with UNIDROIT through its scholarship, internship and research program. So without any further ado, let me invite all of you to welcome our delegation from UNIDROIT today and hand things over to Professor Tirado. Thank you.
Thank you, Professor Godwin, and generally to the University of Melbourne for inviting us. It's an honour and a big pleasure to be here. We come from New Zealand, where we were there for a few days, and New Zealand is not a member state, but Australia is. So for us, it's like a homecoming in many ways. Let me apologize for standing, because I am not Italian, I'm a Spaniard. You know, there's a joke which says, how do you make an Italian keep quiet? You ask him to hold your bags. Because if he can use his hands, he can't speak. Well, in the case of Spaniards, it's more you have to move and when you talk. So at least in my case, if that's okay, I will try to keep within the frame of the. Otherwise, it's also after lunch, so you might fall asleep. Being a Spaniard, I tend to think everyone after lunch falls asleep. So let me explain a little bit what we are. Look, Professor Godwin already provided a very good introduction. We are an intergovernmental organization, which basically means we work for countries. In this case, 65 member states. 65 member states which form what we would like to think it's nowadays a global organization, because it covers about 74% of the world population, our countries do, and more than 90% of the world GDP, so the world market is very well represented. So you can see we have very important parts covered, dark gray. This is very important. We also have Greenland, which is also very important because it's a part of Denmark. So we have all the important parts of the world. We have a problem with Africa, meaning we really try to increase our African membership, but it's difficult because becoming a member of UNIDROIT, like of any intergovernmental organization, requires legislative action. So you have to adhere to a treaty, and therefore, because what we do is very technical, zero political in many ways, it can get difficult to find a champion in the country that would do the job for us. So we were founded 100 years ago, this 20th of April, as Professor Godwin also mentioned, which is quite extraordinary for an organization active in the rule of law. There are very, very, very few that have survived this long without any interruption. We didn't even interrupt the activities during the World War. So, I mean, it wasn't very active, but it was still ongoing, and the governance was meeting even through those years. It was founded in the context of the League of Nations. Those of you who are a bit younger might not have heard about it. The League of Nations is the president of the United Nations. After the First World War, there was a first global attempt at creating a institutional infrastructure that would prevent future wars by providing a venue where countries could discuss. But that's not the part we are more interested in. The part why I'm bringing this up is this is the Treaty of Versailles. This is the mirror room of Versailles where it was all founded. The reason why I'm saying this is those that founded the League of Nations, which deserves much more attention actually than is given normally, were visionaries in many ways. They thought that in order for peace to finally settle, although they were not very successful, you do not just need a framework to discuss agreements, you need adequate social development. So they founded a constellation of satellite organizations, which included the now famous International Court of Justice, then called Permanent Court of Justice, the International Labour Organization, the World Health Organization, the Organization for the Abolition of Slavery, or the International Institute for Unification of Private Law, us. So the idea behind it was, if you want peace, you need social stability. In order to have social stability, you need sustainable growth. So when you hear about economic growth and social stability are linked together. So when you think about the 2030 agenda, 2020-2030 agenda, and the whole idea of sustainable development, and you link it to the UN, you're actually doing something wrong, because it's linked to the League of Nations already 100 years ago. So, sustainability and the law is in our DNA. And many of the instruments that we produce, although very technical, are linked with that. And Professor Veneziano will be speaking about it soon. So first, I think it's also, because this is a university, therefore you are very welcome to question everything that we're saying here. You might be saying, because Professor Godwin already explained, that what we do is our mandate is to work towards harmonization of private law. The idea that countries, if the legal framework, the private law of countries is the same or similar enough to be fully compatible, then there are a number of reasons why that's good for international development and national development as well. One of them is the fact that if there is a harmonized legal system or a compatible legal system, the parties can calculate the risk of the investment adequately because information is there. If you want to invest in another country, you don't know what the law of that country looks like, then the uncertainties are very many, and therefore it's very difficult to gauge the risk of an investment. However, if they are compatible and harmonized, that's not the case. Not only that, but if you know the law or you trust the law of the place where you're going to invest, then there is a reduction in transaction costs, because you don't need to hire a very expensive lawyer like Bruce Whitaker used to be here to find out about the law of the place. You can just rely on a system that you already know, not because it's just like your country's, but because it comes from an international organization that sets standards through a methodology I will speak about, because that's key. So what we do is we harmonize law in that way, improving, in our opinion, by far, what's called a legal transplant, which, believe it or not, has spearheaded harmonization for many decades. It's about cut-pasting the law of another country, which is not a very good practice, because the laws of a country are normally drafted with the very specific framework of that country in mind. And the fact that it works very well in that country doesn't mean anything with regards to other countries. In my area of specialty, everyone copies the Chapter 11 of the United States in terms of insolvency. Every country which is not fully and extremely developed in its market that copies Chapter 11 is unable to apply it. And therefore it creates a lot of problems. We don't do that. We try to provide rules which anyone can take on and incorporate to their system without copying anyone's law. Our laws are the syncretic balance of all the views from all the systems so that they can work everywhere. And we'll speak a bit more about that. Of course, harmonization would be a tragedy if we were harmonize bad laws. So the idea is to create a standard, is a best law that you can harmonize. So that explains the other part of our mandate, which is to help countries modernize their legal systems. So those are the two. And you might wonder then, oh, that funny picture there, you might have heard about a view in the United States, for example, which says, well, but what's this guy, this Spaniard coming here telling us this is such an old-fashioned approach, because the best thing is not for laws to be harmonized, but rather for everyone to country or state to produce its own law and leave it up to the market to decide which law to apply, which is called regulatory competition. If you have regulatory competition, let the market select the best system. You might have heard about regulatory competition in the United States. How many of you has been to the United States? Many of you, I imagine. I was thinking more of the students, I imagine all of you. Okay, how many of you has been to a state or knows a state called Delaware? You've been to Delaware? Oh my God, you're the first person. I've lived for years in the United States. Okay, what is it like? Is it nice? Many companies. Right, so there is this state in the United States that no one's ever visited, with the exception of our friend, that has many more companies than individuals living there. And the reason is that everyone picks the law of Delaware because it's the most flexible of the corporate laws there. And so I don't want to say that this is something we necessarily disagree with, although we do, and I personally do. But I'll give the American scholars that defend regulatory competition the head start of saying, fine, it works for you because it's a national choice within the same country with homogeneity and one market after all. So that's fine. But would it work if it was a global choice of law without any connection? Can we say we are going to apply the law to a subject matter of contract between a farmer and a producer, or anything which concerns access to financing for the supply chain to the country of Ruritania, even though there is no one involved in the transaction in the country of Ruritania? The answer is probably no. It doesn't make any sense. So you cannot apply that rule that regulatory competition assumes lack of transaction costs. You cannot have that if you are choosing between different options globally. So it just doesn't apply. But it's not only that it doesn't apply. Some say, maybe wrongfully, that regulatory competition produces a race to the bottom. A race to the bottom means when there is regulatory competition, the choice is always the law with the fewest rules protecting minorities or minority stakeholders or those involved that are in a weaker bargaining position. You can believe that or not. I'm fine with that. But the main point I try to convey here is that we do not like regulatory competition because we think internationally it doesn't work. And what's more, I think is the most important part, because if you have regulatory competition, you have an enormous amount of squandered resources attached to the whole scheme of things. Everyone has a legislation, only one legislation is used. What happens with the rest? There's a lot of resources squandered. So ex-post choice comes at a cost. What we have is a methodology which produces ex-ante choice of the law. And how do we do this? So how do we produce these best practice standards, treaties, model laws, principles? We do this by calling to our building, 16th century building in the heart of Rome, 10 minutes away from the Colosseum, which sounds lovely, but it's a nightmare because if it rains and there's some water leakage, it's not like you can call the plumber. You have to call the Ministry of Culture of Italy, and it takes a little bit to come and clean it. So this lovely place with a very old-fashioned seats and furniture, we call experts from all over the world to come and help us draft these instruments. Have normally about 8 to 12 experts from all over the world. We have geographic representation. It has to be geographically balanced. It has to be balanced to the extent possible also in terms of gender. And the strict rule is half common law, half civil law, because ultimately the instrument has to be applicable everywhere. And this is one of the most hard things that we have to do and the most beautiful ones that we have to do. Think, for example, I think it's a good example. You mentioned the digital assets and private law principles. So digital assets are seemingly an intangible. The Japanese and the Germans don't think it's possible to have property rights over intangibles, while Americans or English think it's no problem with that. It's a different, so common law and civil law have different approaches to this type of situations. So our job is to come up with a functional equivalent to what would be a possession, for example, in this case, so that you can articulate property rights based on a similar type of reasoning. So we produce the concept of control, which is a factual concept instead of a legal concept. And the idea of creating this functional equivalent to possession, which is control, is actually very useful, and it's a halfway in between, which allows the instrument to work in both types of systems. That's the type of work that we do. I think it's a good example. So we have these 12 experts in the room, and then we call to the room from the beginning stakeholders from everywhere, representative of those that will be using the instrument in practice. So if the market is has specialties in the Southern Hemisphere and the Northern Hemisphere, in Africa, the Americas, or Asia, they are all represented in the room, or we try to have fair representation for that. We have the industry that applies it always because we do private law. So those that would later adopt the decision of choosing a law here or there, regulatory competition, provide their input ex ante in the drafting process, so that this regulatory choice happens before and not after, and therefore you don't squander resources. So that's one of the beautiful things of this, how can we say, international, transnational methodology that UNIDROIT applies. States are involved in the process at different stages, of course, and that ensures also cross-application of the instruments and adequate representativity of them. But I think the methodology is actually quite interesting. And historically, transnational law instruments have been divided between hard law and soft law instruments. That's a complete misnomer, because in reality, they are all soft, and they are all meant to be hard. Why are they all soft? Because a treaty, even a treaty which is approved in a diplomatic conference with 90 states, is not applicable law in those states unless and until the state approves it by legislative process. So it is soft until it's hard because there is a parliamentary action at the country level. Soft law, or model law, for example, on factoring, is soft law in the sense that it is not applicable law directly, but if a country wants to incorporate it, it has to pass legislative action, passing the model law as national law on factoring. So ultimately, soft law is designed to be hardened ex post. So in both cases, you need parliamentary action, and it's not that different. What's very different is the process leading to a soft law or a hard law instrument. Soft law is much easier to do. Negotiators and countries come to the room with a much more open spirit. If you are negotiating a treaty, countries that haven't got any intention whatsoever to ever ratify it, nevertheless come to try to make the treaty look as much as possible to their own law. Why? Don't know, but that's national vanity, perhaps. We don't know what the reason is, but that's how it is. So to give you an example, one of our most important treaties, the Cape Town Convention on International Interest in Mobile Equipment, which sounds really boring, but it regulates over 60% of the world leasing of aircrafts. So in this registry in Dublin, we have assets worth over $1 trillion, more than 1.8 million registrations in the registry, so it has its own importance. It's a very successful commercial law treaty, which has proved its worth for 2 decades. There is in 2019, Will was the driving force behind it. We approved in Pretoria the MAC protocol. So the same we do for aircrafts, we do it now for mining, agriculture, and construction equipment, key to development of less developed economies because it helps access to credit to use high-value tractors and agricultural machinery. Also, Bruce was a key, and Megumi were both key parts in the negotiation of that treaty. Well, it took us 13 years to finish the process. And it was a no-brainer because it was the fourth of a treaty which already had proven it works. So you can imagine, now think that most of our work going forward, current but also going forward, is going to be based on sustainability matters or technology. Imagine that we get together to discuss something which relates to technology and we finish 13 years later. What will that be good for? Not even obsolete, so it will be an understatement. So it wouldn't be possible. That's why the numbers already in the old years already reflect a scarce use of treaties. So almost 37% of UNCITRAL's treaties never came into force. 1/4 of our treaties never come into force. So it's still, even in the good times, there were reasons to walk away from hard law, from treaties and move towards soft law standards, but nowadays is clearly the way forward. And I will finish this part by explaining a little bit how our instruments become national law ultimately. Our instruments are on our website, legal instruments, model laws, principles. They are there up for grabs. Any country can just download them and use them if they want to. And those are designed to do cut and paste, unlike the law of United States or the law of Germany. But normally, because they're very technical, the countries that could use them more effectively or would need more, have a bigger need of the use of those instruments, are not prepared. We don't have the human resources to implement those instruments. Normally, it doesn't just happen that they download the instruments. They take an interest in them, usually through intermediaries. And very often, sometimes, rarely, it's a national development agency. For example, they already recently obliterated USAID, which did a great job for many years around the world. I think Australia has also a development agency that takes, does it? Yeah. Part of foreign affairs, right. Well, so there are some development agencies that help countries do that in their regions of target regions. But this happens mostly through international financial institutions like the World Bank or the Asian Development Bank in this region. So they act as intermediaries for the drafting for the modernization of the legislation. What type of instruments do we do? Professor Godwin already mentioned many of them, but I will just very briefly refer to the different work streams that we have. Contract law is one for which we've been very usually identified as global standard setters. There is the Universal Principles of International Commercial Contracts, which last version of which was 2016. That seems to be there. And this is general contract law. It's a restatement of contract law. But we are trying to develop that sectorially. So we did an adaptation of UPIC to reinsurance contracts, where there was a lot of fragmentation. We're doing the same now with investment contracts, and there will be a whole section on that. Banking and capital markets, one of our most recent instrument, the legislative guide on bank liquidation or bank insolvency. Very important, first time that we are aware that an instrument of this type leaves Basel. Basel is a city in Switzerland where all the central bankers meet to regulate in the area of banking regulation, but they're still normally confined to working there. They came and worked with us to Rome, and we did this together with the Bank of International Settlements, which is the signature Basel institution. So we take lots of pride in that. Our work on access to credit is absolutely key, our bread and butter. We believe that that's the way to help countries grow on their own without receiving external financing, but themselves creating the financing. And for that, we have, for example, asset-based financing, which is key to for the use of certain specific assets. You get financing just for that asset. Then we have work on perhaps the most important asset that any good business idea has. If you go to, you have a business case in your head, you have a good business entrepreneurial idea, and you want to take it to reality, you're going to need some financing. This is what happens with startups, blah, blah, blah. So you go to your bank, and maybe not here, but in most countries in the world, especially less developed jurisdictions, they're going to say to you, give me land or give me assets as collateral. Otherwise, I'm not giving you anything. That's what happens. Most micro entrepreneurs don't have any of that available, so they can't access credit. So how do we do it? By providing a model law which modernizes supply chain financing, so receivables financing, factoring, reverse factoring, etc. We are making sure that the factual realization of a business idea, which is its future cash flow, is captured as the main collateral for the financing. So that's the and then we have now the link missing was most of these instruments are, many of these instruments are at the request of the World Bank. So because they are on the ground identifying the needs of many countries. And so they came with the last proposal to do work, which closes the loop, we think, in that area, which is what happens when there are no financial institutions willing and able to finance small startups that have a new idea out there. Well, what happens is you can democratize access to credit by negotiating through a platform the issuance or the issue of bonds and securities which anyone can access and invest in a small amount. So it's this investment-based crowdfunding that is closing the loop in access to finance for small amounts, which were key for the beginning of an activity. And we are starting to do that model law together with the World Bank. Digital assets and private law was already mentioned. So I just finished by saying that much of our work is now based on technology. As you could hear, platforms for access to credit. The same happens with our signature work on verified carbon credits, or voluntary carbon credits, which Anna will explain now. And that is a neat project because carbon credits relate to both technology and sustainability. And that's the way forward for the organization, I think. So I think I've spoken a little bit too much, but that's okay. So Anna, you take it from here. You go. Anna is Italian, so she doesn't need to talk.
Thank you very much, first of all, Professor Godwin, and to the University of Melbourne and the Centre of Commercial Law. We are delighted to be here. Thank you for being here. And yes, it will be a challenge because I'm Italian and my hands are both full, so I don't know whether I will be able to speak. But in any case, we'll go to UNIDROIT work and sustainability. What we would like to do, and I use the we, not as a royalty, but because we will split this presentation with Professor Hara, particularly for the part on verified carbon credits, because she's one of the main experts who is participating in this work. So what I would like to do is, first of all, introduce the fact that most of the work that is done even in the past by UNIDROIT is connected one way or the other to the sustainability goals of the United Nations. In particular, the Partnership for the Goals. Why? Because we are an intergovernmental organization and we collaborate more and more. This is a development in our methodology with other organizations who work on the field and have first-hand knowledge of what the problems are and work towards an amelioration of the conditions of life in particular, but not only in different countries. So, for example, we work together with the FAO and IFAD, who are also based in Rome as UN agencies, and our work on private law and agriculture, which you see here mentioned with contract farming, with the land investment contracts, and with a project now on collaborative structure for agricultural enterprises. They are all part of this partnership for the goals. We also work towards, generally, all our instruments are connected one way or the other with the idea of introducing the rule of law, and therefore strengthening in this way also institutions and justice. In a way, you have heard what Ignacio said at the beginning. We were born with the League of Nations, and the idea was that the law can serve as a way towards peace. So we continue to think that this is one of the possible outcomes of our work. But there are some work streams of UNIDROIT which are more connected to the idea of sustainability. For example, the work stream on access to credit, I think Ignacio has already explained and alluded to that, including the access to credit for small enterprises, small to medium enterprises in the agricultural sector, for agricultural production. It touches upon quite a few of those sustainability goals, and in particular the ones which refer to economic growth, but in a sustainable way, and also in a reducing inequalities, which is another important goal, and the same for the work stream of private law and agriculture that I have already mentioned. But because of the time at disposal and because of the fact that we have some instruments that are more thank you very much, that are more really tailored to certain goals, in particular the climate action goal, we will go to one of the projects that we are now developing and that it's reaching almost its conclusion, which is the project on verified carbon credits that Ignacio already mentioned. So first point, you probably all know what a carbon credit is and the importance of carbon markets. This is just to recall that they are recognized as a crucial means to challenge resources into initiatives combating climate change. And the fact that you have a strong carbon market is seen as critical to fight climate change, achieve the goals of the Paris Agreement, and facilitate the fulfillment of the UN Sustainable Development Goals. So when you think of carbon credits, there is a definition, and then our instrument has refined this definition for private law purposes in particular, but carbon credit means a unit that represents a mitigation achievement of the equivalent to 1 ton of CO2 as a result of a carbon mitigation project. And those projects could be mostly of two types. Projects that reduce CO2 or projects that remove CO2, or there could, of course, be some overlap of the two. And for this reason, we have here two examples. So this is one example that is of a reduction of CO2 emissions. And the reason why we are showing these two examples is not only to better explain what type of mitigation projects are actually used and where carbon credits can play a role, but also to show that this is something that it's already existing, that it's not limited to the compliance markets under the Paris Agreement, but they are also used in so-called voluntary markets for various reasons, including the possibility to raise financing for different types of projects which have the goal of reducing or removing CO2 emissions. So this one, the first case is it's a fictitious case, but it's based on because the names have been changed. It's a real case, but it's redacted because, of course, we use the country Narnia instead of the real countries, and so there is a great investment in building a network to supply bioethanol cooking fuel to low-income urban households in Narnia, and with half of it going directly to consumers as subsidies, the company sells cooking stoves and fuel at below cost and recoups losses by selling carbon credits. So here is where the carbon credits come to the fore. How do you generate these credits? They are generated through calculations about how much deforestation and therefore carbon emissions are avoided, reduction, by low income households switching from cooking with charcoal to using bioethanol made from sugarcane. And this is an important element that will be also discussed later. Those credits are certified. There are certifying organisms by the verification organizations, the Good Credit. There are also estimates done by the organizations we work together with that this is the fact that you continue to use charcoal fumes may have a very negative impact on various, but in particular also on the health of families. So recently, the government of Narnia signed an investment framework agreement with this company that would allow it to sell those credits into the compliance markets, so they can be also used in compliance markets under Article 6 of the UN Paris Agreement. But it could be that, for example, those authorizations are not issued, or in any case, these credits can also be used in a voluntary market. So this is the first example. We have a second example, which is, again, true example with some slight reduction and changes. And here we have an example of removal, because we have a afforestation, reforestation group project. Here we have a real country, Tanzania. And it restores degraded cattle ranching and pasture lands by establishing mixed native hardwood plantations, enrichment planting, and so on. So I'm not going through the whole example, but the idea is here you have a project, the goal of which is to, with time, remove carbon emissions, and then there is a verification period for the project whereby a certification is received that an important amount of net removals has been achieved, and therefore it is possible then for the certification organ or agency to issue carbon credits which are based on this calculation, and until they are retired, which means that they are actually used, they have finished their purpose. So those are the two cases we wanted to present. We can then discuss them perhaps together later on, but the idea of these cases is especially to show that carbon credits are used in practice. They are used for these types of projects, to finance them in particular, or for other reasons. They are used not only in compliance markets, but also in just voluntary markets. But despite the recognition of their importance and their use in practice, the legal nature of carbon credits remains uncertain in most jurisdictions. And actually what happened was that our Secretary General was approached by ISDA, and ISDA was the reason why they asked us to work on this project was that they said, we are using these things, but we are not really sure on what they are from a legal point of view, and especially how you trade with them, how you transfer. Are there any certain reasons on important elements that deal with the private law applying to these credits, which, to which, of course, you might apply national property law, but to what extent this is possible. So the goal of these principles is to provide legislative guidance, so the addressee in this case is mostly a legislator, though not only, on key private law issues, to enhance the confidence in these transactions and support, therefore, the development of well-functioning carbon markets. And therefore, what are the key private law issues that are included? In particular, what happens, how transfers of VCC may be completed by sale, how, if you can use them as a collateral to secured financing, and also how do you treat VCCs held by entities, for example, in insolvency? So all issues that are typical property private law issues, but for credit, for these strange objects that it's not really clear how they could be developed. So now I will leave the floor to my colleague, Professor Hara Megumi, because she will continue with what is the core of this project, the legal nature of VCCs and the proprietary rights that can be created over the VCC. So what is a VCC under private law, Professor Hara?
Thank you very much, Anna. And Anna is letting me take over this part because I'm very much a property law academic. So let me just very briefly start with what Anna has mentioned, why the legal nature of VCC is so important. It is not simply a theoretical question. The characteristics that we give these VCCs or our asset is very important because it will determine which legal mechanism it will fall under, right? Which legal mechanism of basic private law it will fall under. Does it fall under contract law? Does it fall under property law? All these things will be determined by how we characterize that legal nature. And especially it is important when we think about when the party's intention is not really clear, or there is a third party effectiveness that will determine, for example, priority rules or anything to do with insolvency. You need to know what the legal nature of the VCC is. It is also important when you look from a broader sense. If we can characterize VCC as an object of proprietary right, we can give it a legal status as an asset with economical independence or importance. So it has a value. We can conceptualize it that it has a value. So it is really important. However, as we know, intangible assets are generally not organized under one single coherent legal category, like a tangible asset. So we really need to determine what this specific intangible asset, the VCC, can be recognized under private law. So that is what we are doing. And as you can see on this slide, there are different possibilities in ways that we can probably categorize VCC. So one example would be, could it be, like I said, a transferable contractual right, so which would fall under the rules of obligational law or contract law? Could we do that? So is it essentially a claim against the registry, which we register the VCC, that administers that carbon credit, and that this VCC holder has a contractual right against the registry? Can we do that? This approach raises problems really quickly, because if registry were to become insolvent, the existence of the credit itself could be called into question. We don't want that because we want to have an independent economic value to this asset. We want certainty to that asset. Another possibility is to treat it as a digital asset. However, under the UNIDROIT digital asset principles, digital assets are typically defined by factual control over digital objects. Factual control, let me give you a brief definition, is that it has a practical ability to use, transfer, exclude others from digital asset, typically through, as you can imagine, a control of private key, right? So that's one example. And that is done without needing the cooperation of another person. That is not possible for VCC because you always have the registry involved. So you cannot conceptualize factual control when the registries are necessary by definition for VCC. So we cannot use the digital asset analogy either. The third possibility is to merely treat it as a information. Many of the jurisdictions, and I understand even under Anglo-American law, information cannot be an object or it cannot be a property, right? It cannot be that in German law or in Japanese law as well. So if you say it's a mere information, you cannot give it a subject of proprietary rights. So we don't want to do that either. So for these reasons, the approach developed by the draft principle is to treat the carbon credit as a thing that has characteristics necessary to be the subject of property rights. So how can we do that? If you look at the slides, you will see that there are certain characteristics that we give under traditional property law to subject of proprietary rights, and that BCC actually meets these criteria. So first, carbon credit is individualized. So each credit is registered using a unique identifier in the registry. So it can be identified. Second, carbon credit can be controlled. Yes, I did say that you cannot have a factual control that doesn't involve anyone else, but it can be controlled because the registry is there, and that you can actually, through the registry system, the holder can control, transfer it, or to retire that credit. So that means that there is some control. Third, a carbon credit is libelous. So why is that? If one person controls or uses that credit or retires it, another person cannot use it. So this exclusivity is very important for the characteristic of proprietary rights or property-like rights. So finally, a carbon credit can be transferred. So transfer occurs by debiting the seller's registry account and crediting it to the buyer's account. So transfer is possible. So you can see that there are characteristics of property-like rights that we can give to VCC. That's how we became to justify the fact that the VCC is a subject of property right. And this is very important when we want certainty in the market.
Thank you. Thank you very much. I wouldn't like to overspeak in the sense of continuing too much on this, but I just wanted to show that there are also other issues of not only of property law, but generally of private law that are important for this particular project. And I would like also to say something that will probably also discussed by Professor Hara and also by Bruce Whitaker in a moment, which is these working groups are an exceptional venue for experts from very different jurisdictions, but also, and this is the methodology that we use at UNIDROIT, those who are directly involved in the market with different roles. For example, we have the registries there. We have the representatives of the registries. We also have those who deal with the financiers or those who deal with these credits, and therefore they can tell us what they do in practice and whether a legislative or legal guidance is needed, whether there is a gap. And actually, the most interesting thing about this project was that we saw that there were different ideas of what different terms may mean. And so one of the main objectives of this discussion at the working group was also to clarify the main the terminology that was used and the different let's say aspects and of the life cycle of a verified carbon credit. And we think we have done that, or the experts have done that. And here you see, for example, different ways carbon credit can be cancelled, which means that ceases to be capable of being the subject of a property right, either because it does not longer meet the definition because of supervening events. This may happen. For example, a fire that destroys a reforestation project, or it is subsequently demonstrated that from the start there was a problem, that the mitigation or reduction project did not meet the characteristics, or what would be the normal outcome, the usual death of the carbon credit, which was is the retirement because it has fulfilled its use. So all these are clarified. So I don't think we have the time to go to other projects of UNIDROIT that are very much connected to the idea of sustainability. We have them in the slides. Perhaps we can come back to them in the discussion. One of them is, for example, a project that was already mentioned by Ignazio, which is in the field of contract law. So if you're interested in this field, we have, of course, our UNIDROIT principles of international commercial contracts, which are contract law in general, but we are also working to developing certain more specialized instruments for specific contractual types. And one of them is international investment contracts, which of course has very special characteristics, not only, but partly also because one of the parties is a state or a state agency. So it was felt, and we worked together with the ICC World Business Institute, that more guidance was needed. So it's a soft law instrument, principles and commentary, model clauses and commentary. And one important part of this instrument is how to contractualize the sustainability requirement or the sustainability issues, how to make not only contract law include those issues, but also how to make them part of rights and obligations of the parties and remedies in particular, that they really achieve the goal. Dispute resolution. What is the new development of stabilization clauses if there are super legislative developments, which could be also in favor of protecting the climate, for example. So I'm not going into the detail. I said I wouldn't, but as all professors, I usually lie when I say that I speak less than I should. So I will really stop here, and thank you very much for your attention.
Okay. I'm sorry that I'm back again. I think I've been asked to speak a little bit about the role of experts in UNIDROIT. So I'll just be very quick because I've already overspoke. I was trying to think of what I feel my role should be in UNIDROIT, and this was actually the first time I actually verbalized this. So I hope I'm correct in that they will not kick me off any working groups. But I see myself as a bridge to many different things. So in Japan, I've always worked in a very theoretical field of property law. So I used to think when I was a graduate school student that I would like to write an article that is read in 100 years. So I was very young, I was like a baby, but that was my idea of how a graduate school or any academic article should be, that it's something that is valuable in 100 years. That has drastically changed while working with the government or working with the international organizations. I see more of myself as, yeah, theory is very important, but having discussion with how legislatures think or with the industry and being able to bridge all these ideas into one legal structure is part of the role that the academics could play. And working within the Japanese government as well, we tend, in Japan, we do have academics involved in legal reforms. So I've been lucky enough to be involved in property law reforms and secure transaction reforms. Even in that capacity, we do comparative law. So Japanese law tend to have always a comparative law components to it when we change our law. So there would be an Anglo-American professor doing research on that, French law, German law, recently maybe Chinese law as well. So those kind of comparative law method and trying to bridge that into Japanese legislation sort of gave me a way to think the same way when I'm involved in international organizations as well. So being a bridge between industry, academics, Japanese government, also being a bridge between civil law and common law, trying to think what is the actual core elements is really very important. It's a theoretical game that not a game, but theoretical ideas and theoretical thinking that we really, really need to be clear on, because as Ignacio said, we need to think in terms of what we can do functionally, what kind of result we want to achieve. We want to be very clear on that. So in order for me to be thinking in that way has been what I want to ideally achieve in international organization, and that is what I'm trying to do for the moment. Sorry, I talked too much.
Thanks, Megumi. Quite a hard act to follow. As you heard from Andrew's introduction, my background is as a banking and finance lawyer in private practice, so when I got involved in UNIDROIT's work, it was natural for me to get involved in their projects that relate to improving access to credit. And access to credit is not just a theoretical concern, it has real world importance. The World Bank and other international organisations over the years have done any number of studies that demonstrate very clearly that one of the greatest impediments to economic growth in the developing world is whether or not businesses, and particularly small businesses, have adequate access to credit at reasonable cost. That is one of the things that most holds back economic growth in the developing world. And there are usually many reasons why small businesses might not have access to credit, but very commonly one of the major reasons is that these countries simply do not have well-structured, modernised commercial laws that make it legally possible for business to get access to credit. Banks are not going to lend money in a country unless they're confident that the laws will allow them to get their money back when the loan matures. And many countries simply don't have laws that make that possible. In particular, many countries don't have laws that make it easy for businesses to use their assets as collateral for loans. And in these countries, economic or bank lending or finance lending, commercial lending is only in very small amounts. So a lot of the work that UNIDROIT does and the projects that I've been involved in has been trying to develop instruments that countries can use to improve the quality of their commercial laws as one of the steps you need to take to improve this access to credit. Now, I was at this point going to draw a distinction in UNIDROIT's approach to this topic by talking on the one hand about hard law instruments and on the other hand about soft law instruments, but I've now learned that I'm not allowed to do that anymore because apparently they mean the same thing. So instead I'll talk about the processes that I've been involved in UNIDROIT for the development on the one hand of treaties and on the other hand of model laws. Treaties, as you might expect, developing treaties is a very formalised process. In the UNIDROIT process that I've been involved in, which was the development of the protocol to the Cape Town Convention, after an initial general period of work by an informal working group, they convened 2 meetings of experts, international government experts, where each member state of UNIDROIT nominated one or more subject matter experts to attend a series of meetings in Rome, so not exactly a hardship posting, to try to develop the form of the protocol. When that had been sufficiently developed, UNIDROIT then convened a diplomatic conference which was held in South Africa in 2019, I think I've got that right. So over a 2-week period, representatives of member states met in Pretoria to finalise the text of the treaty and then formally adopt it. And those representatives were again a combination of policy people from governments, but also still a strong representation of subject matter experts just to make sure that the final content of the document reflected what we really needed it to say. So that was a fascinating process. So very political, as you might expect, very diplomatic, but a fascinating process for me as a private law academic to watch and be part of. Treaties are not easy to negotiate. Once the form of the treaty has been finalised, that's it. There's no real room to manoeuvre. A state then either adopts the treaty as it's been approved or they don't adopt it at all. That's why it gets called hard law. Maybe a better word for it is inflexible law, because there is almost no capacity to tweak the wording of a treaty to suit a state's particular needs. Model laws, on the other hand, are a much more flexible beast, because here we're not trying to develop an instrument that states are bound to use in any particular form. Instead, we're developing an instrument that states can then use as a starting point for developing a law that then reflects their particular circumstances. So it's a much more flexible approach to preparing the instruments. Professor Tirado talked a little bit about how they go about building the working groups that develop these model laws. They bring together subject matter experts from a wide variety of geographies, a variety of legal traditions. They have representatives both from the public sector and from the private sector, and they have representatives from the academic world and also from the practitioner world. So the objective is to bring together a group of people who all understand the subject matter, but bring very different perspectives to bear on what the issues are and how they can best be addressed. So again, go through for what was for me quite a fascinating process of talking through, firstly, what are the issues that you want this law to address? And once you've reached agreement on that, you then say, well, what are the options? What are the various ways that legal systems around the world try to address these issues? And you try and pick the eyes out of all the different ways that different countries deal with these issues and come up with a solution that is best of practice or best of breed, best practice, but at the same time is not overly reflective of any one particular jurisdiction, and so is in a form that both legally and politically is one that can be used by, we hope, any country around the world. So you go through a series of meetings, some of them online, again, most of them in that hardship posting of Rome, in this wonderful ancient villa that was built by a pope, don't know how many centuries ago, I've forgotten, but in a very beautiful part of the world that's about halfway between the Colosseum and the Trevi Fountain. And you work very hard for 2 weeks or a week and try to develop the instrument that you think reflects what you think it ought to say. And at the end of that, when you've reached the end of your work, that I think goes back to the Governing Council. Governing Council gives its final approval and then the document is published and launched. So for me as a private practitioner, there was a bit of a crash course of comparative law in all of this, because all of a sudden I was realising, let me take that back one step. When you work as a lawyer and you've been trained in one particular legal system, you tend to think that your way of doing things is the right way of doing things, because that's just the way your brain's been trained. So to all of a sudden find that there are all these other different ways that other countries have come up with to deal with these issues, all of which can be perfectly valid ways of approaching a topic, but they're just different to the way you've been trained to think about them. That is quite an eye-opener, and it does take quite a while to reshape your thinking to get yourself comfortable with approaching these different topics in all these sorts of different ways. But it's certainly, for me, was a very enriching experience, and it was for me a real privilege to have been and to continue to be involved in these processes. That's about all I think I was going to say, but I think I'm now handing over to Will, who can tell all of you how you may be able to get involved in some of these processes as well. So thank you.
Thanks so much. As the resident Australian on the UNIDROIT Secretariat, it's a real pleasure to be here in Melbourne. I think this panel has demonstrated that there are many paths to UNIDROIT, whether you're an academic, private practitioner or a former government official. There are many different perspectives and roles that we take in formulating our instruments. So I've got the easy job today, and we're a little bit over time, so I'm going to compress my 10 minutes into 1 minute. We hope we've convinced you that what we're doing is interesting, valuable and worthwhile, and we'd like to outline very quickly how anyone in the study of law can be involved in the work of UNIDROIT. While we're an intergovernmental organisation and our 65 member states are our core clients, we do have what we call the UNIDROIT Academy. that brings together our connection with academia and with non-governmental stakeholders. And probably the most relevant part of the 8 different initiatives under the UNIDROIT Academy is our research, scholarship research and internship program. We've been running it for over 35 years. We've brought over 800 experts from over 70 countries to UNIDROIT to work on our instruments, to study our instruments through this program. Essentially, the scholarship component is more aimed at PhD students, postdocs, professors who are already somewhat established in their field, and they come to UNIDROIT for a period of 1 to 2 months to work on research that is connected to our subject matter. Of course, you're very welcome to come and study any matter of private law, but if you're applying for UNIDROIT funding, we strongly advise you to connect it to one of our instruments, either being negotiated or recently adopted, because obviously that's of particular value for UNIDROIT. The internship program, of course, is more aimed at students. Usually very limited possibilities for undergraduate students, but I understand that's not an issue here because it's all postgraduate at Melbourne. We bring in about 60 interns every year from around the world to work for a 3-month period. It's very different to a scholarship and a research position because you are really absorbed into the Secretariat. You're treated as a junior member of staff. You work directly with a legal officer such as myself, and you'll be assigned to a specific project. So it's very different to a law firm and a very unique opportunity to get a first-hand, I guess, insider's view of what it's like to negotiate an international instrument. It is very competitive. We get almost 500 internship applications a year and about 250 scholarship applications a year, so only about 10% get through. We try to fund as many as possible. The nice thing about being in this part of the world is that we actually have a Asian Transnational Law Centre that provides additional funding for applicants from the Asia Pacific region. So we try to provide our scholars we provide our funded scholars with €1,500 a month for 2 months, our interns with €1,000 a month for 3 months. That doesn't cover all the costs of living in Rome, but it does help. You can see here that we're getting actually majority of our applications from the Asia Pacific region, which has been a change in recent years that we're very pleased with. And my last piece of advice, because I do want to move to questions, is if you'd like to apply, and this particularly is in relation to, in both interns and scholars, look very carefully at our recently adopted instruments, look very carefully at our ongoing projects, and don't necessarily choose the most popular, sexy one. Because as you can see here, we have 35% of our applicants applying for international commercial contracts. Of course, it's our most famous soft law instrument, one of the most important soft law instruments in the world in private law. But access to credit, my area, a paltry 3%. Private law and agriculture, 2%. And similarly, capital markets, financial law, 6%. All of these areas have legal officers on them. They're all drawing upon the scholars and interns that apply. So if you apply, obviously you should have a genuine interest in the area in which you apply. But if you apply for something that is got a high priority on the work agenda, but is perhaps a little bit outside the norm, you're much more likely to be successful. And we do always, more recently, we've been getting about 5 to 10 applications a year from Australia. And Australian university applications are very highly prioritised, not only because of the quality of education here, but the also teaching in mother tongue English is also extremely valuable for the institute. So, yeah, and of course I just, and I apply favouritism. No, we run an independent process. Thank you very much for your time.
Let's put our hands together for the panel. That's been a really informative and comprehensive overview of what the organisation UNIDROIT does, the type of projects on which it works, and also what different people within the organisation and the external consultants do to help bring these projects to reality. So unfortunately, time is up, but I'd be grateful if you could please put your hands together to thank our panel. And finally, thanks to all of you for coming along to the event today.